All right. I think the hour has arrived. The hour has arrived. We're fortunate, very fortunate in having with us today Professor Richard Levy, who's a distinguished has a chair as a distinguished professor in the KU Law School. He's a professor of constitutional law. And he's going to be speaking to us today about presidential power and the Constitution in the Trump administration. This is a subject that is looming larger and larger in the news every day, as you know. We're going to vary our format slightly this time. Rick's going to speak to us for 20 minutes, address us for 20 minutes, and then put up 10 or 12 topics, which we may then choose to address and discuss. So 20 minutes of presentation and then some discussion. So with no further ado, I'll leave it to Professor Lee.
So I guess I should start by thanking you all for having me here and for coming. I think we have a pretty good turnout. It seems like they keep bringing out more chairs. I'm going to assume that's because of the topic rather than the speaker. Although maybe I should think about it the other way for my own ego purposes. So this is a topic that's somewhat challenging to speak about for a couple of reasons. So one reason is I've got 45 minutes to an hour and a half to talk about it. I think I can maybe scratch the surface of some of the issues that are showing up, but there's no way we're going to cover everything. And as suggested, I thought the way that we might make this most appropriate for the audience would be for me to make some general observations and points about presidential power, and then to allow the audience to steer me to discussion of the topics that they have the most interest in. And I started to make a list, and when I got to about 11 topics, I thought that was probably enough, and I stopped there. The second challenge, talking about this particular topic, is not to become overly political in thinking about that. This is a problem I run into a lot teaching constitutional law. It's hard to separate what constitutional law is, or maybe should be, from what we want it to be, or what we would like it to be. That's a problem that the Supreme Court struggles and fails with frequently. And my goal will be to talk about these issues without regard to whether I agree or disagree with a particular policy that the Trump administration might be pursuing. That is, I'm going to try to separate thinking about the scope of federal power from the question of what federal power, or excuse me, presidential power, from the question of what presidential power is being used for. And this presentation is actually an outgrowth of an article I did and a presentation that I've done looking at the Obama administration and the Trump administration through the same lens and sort of comparing the two administrations and their use of presidential power. So chances are I won't be perfect in divorcing my views about what policies should be pursued by the president from the president's power, but I will do my best and focus on the question of presidential power. I guess a final observation, I was getting all kinds of criticisms about my pictures before the talk started. They were just meant to be a little teaser, no hidden meaning in any of it. Okay, so first general starting point is to understand that since the time of the founding, presidential power has been on a growth trend. And it's been expanding fairly consistently, maybe not at a uniform rate, but it seems to be getting bigger. You never really see it getting smaller and going in the other direction. So this is a general trend over time. It's partly driven, I think a lot of it is driven by practical politics and matters of necessity, particularly when we deal with issues of foreign relations, national security matters. There's a perceived need for the president to be able to act quickly and unilaterally in order to deal with pressing threats. In a larger sense, there's that feeling about domestic policy as well, although perhaps not as starkly. We've also seen in this area particularly a kind of historical ratchet effect. So once the president has done something once, that operates as a historical precedent for the president to do it again, and it becomes a platform for the president to take another step towards a greater expansion of presidential power. So in particular, the use of military force, we see that sort of pattern where we can start with unilateral use of force, for example, with Lincoln's blockade, and that provides a platform that we see expanding over time, and we eventually get to things like the war in Vietnam, in which we have all-out war without any real congressional action. So in recent years, this general trend over time has been accelerated by what we might describe as congressional dysfunction, trying to be as generous as possible at that point. The congressional dysfunction really contributes to the growth of federal presidential power, in two ways. So at one level, it creates a policy vacuum. When Congress is unable to address policy issues that are pressing and require some sort of governmental response and becomes paralyzed, then the inclination is for the president to say, well, I have to do something. I'm going to step in. If Congress won't help, then I'll do it myself. A classic example of that would be in the area of immigration policy, where first President Obama took some fairly dramatic steps with the DACA and DAPA programs that created certain rights for undocumented aliens. And then President Trump's response is equally strong in terms of filling in the policy vacuum. And that becomes necessary or perceived to be necessary, or at least politically expedient, because Congress won't do anything about these kinds of issues. A second reason why congressional dysfunction contributes to the growth of federal presidential power is that Congress can't respond when the president does assert power broadly. So in the balancing of presidential and congressional authority, the framers thought that Congress would defend itself when the president sought to exceed the scope of presidential authority and encroach upon the legitimate realm of Congress. But now Congress is paralyzed and the president does something and Congress can't respond, even at times when the politics would seem to suggest that they would or could. Maybe a good example of that would be President Obama's deal with Iran, which at the time it was struck, many members of Congress objected to, some of them in open letters to the leadership of Iran. And Congress, in fact, passed a statute requiring the president to submit the Iranian agreement to Congress for review, with the idea that that would then facilitate some sort of congressional response. But Congress was paralyzed. It neither approved nor disapproved the agreement that was presented to it. So it was paralyzed and was unable to take any meaningful response to a broad assertion of presidential authority, even though both the House and the Senate were controlled by the Republican Party at the time. So in recent presidential administrations, we see pretty dramatic growth of presidential power and assertion of that power. And each administration seems to have, I guess, its own characteristic in that regard. So for President Bush, the 9/11 disaster and the war on terror, Patriot Act and all of those things led to a very dramatic expansion of presidential authority, particularly in respect to national security matters. In the Obama administration, after the first 2 years of his term in office, Congress was controlled by the Republican Party that vowed to obstruct everything that President Obama wanted to do. And so he was prompted in many instances to take unilateral action because he could get no cooperation from Congress. And then I think the Trump administration, I'll just call it the president as CEO. And so under the Trump administration, his view of the presidency is that, like a CEO, the president ought to be able to run the country and do whatever the president thinks is in the best interest of whoever the majority shareholders of the company or country are. So each of these presidents, for his own reasons, has asserted presidential power broadly. Each has done so more than previous presidents, including previous presidents on the list. So we see a pretty dramatic and strong expansion of presidential authority. So that's kind of the stage that we're operating on, set that stage. So now let's think about how that implicates separation of powers. So the basic principles of separation of powers, I think you're probably all vaguely familiar with them. Let me just highlight some key points so that we're all on the same page, or PowerPoint slide. So legislative power is first. It's generally regarded as the antecedent power in the sense that it's the one that's exercised first. And it's the power to enact binding legal rules or laws. Those binding legal rules or laws prescribe the ends and means of public policy. So they determine what public policy is seeking to achieve, employment, tax cuts, etc., and how they're going to go about doing it. And of course, the legislative power is exercised using bicameralism, meaning that both the House and the Senate must pass identical laws, and presentment, meaning that those laws have to then be given to the president for a signature or a veto, and if the president vetoes a bill, it can be overridden by a 2/3 majority of both the House and the Senate. So legislative power, at least in theory, is the superior power. It's the controlling power. And the framers thought of Congress as the most dangerous branch of government. Executive power, by way of contrast, is derivative in the sense that the president's power to implement the laws derives from the laws that empower and direct him to take actions. So the president's power, for example, over immigration comes from immigration law. And in that sense, it is derivative. And it includes the power to appoint and remove the officers that implement the laws and to oversee the execution of the laws within the executive branch. Now, in the domestic area, the president's powers are almost entirely derivative. In foreign relations matters, however, the president has some substantial independent constitutional authority. Probably vaguely familiar with that. The president is the chief representative of the United States in foreign relations matter, diplomatic relations. The president negotiates treaties, although those have to be ratified by the Senate, and also other kinds of agreements. And of course, the president is also commander-in-chief of the armed forces, although only Congress can declare war. When we think about the executive branch generally, The common constitutional perspective is that the framers of the Constitution thought that the executive branch should be a unitary branch headed by a single individual at its apex. So that's the unitary executive principle. The Article 2 of the Constitution, for example, vests the executive power in the president. Doesn't say in the executive branch, cabinet officers, etc., in the president himself. And the president is given specific oversight responsibilities. It's the president's duty to take care that the laws are faithfully executed. And so finally, the third branch of government is the judiciary. The judicial power is the power to resolve legal disputes, generally referred to as cases or controversies in the Constitution, that are within the jurisdiction of the courts to resolve. So the courts are generally a reactive institution. They don't reach out and decide matters. They wait until parties bring a dispute to them. And their power to interpret and apply the law and to review executive and legislative actions derives from their obligation to resolve legal disputes. So when courts resolve legal disputes, they apply the superior law as controlling. So if a constitution and the legislation are in conflict, they apply the Constitution, it's the superior law. If legislation and presidential action are in conflict, courts apply the legislation, it's superior to presidential action, provided, of course, the legislation is constitutional. And of course, we value the independence of the judiciary, and so the Constitution protects the judiciary's independence through life tenure and salary protections. Everybody with me on that? Okay. Now, those are the basics. Now, I do want to add a few observations about separation of powers in practice. So it's easy to summarize separation of powers principles, but there are countless particular issues that arise in relation to separation of powers that have to be resolved, and a lot of those are issues for which there's no clear answer, where you have to derive or think about principles and how they apply in specific areas. So one issue in separation of powers in practice is whether we approach separation of powers in a formalistic or functionalistic way. And sorry about the terminology, but that's the ones that everybody uses. So from a formalistic perspective, separation of powers is strict and categorical. There's legislative power, there's executive power, there's judicial power. They're all separate and distinct. You analyze a separation of powers problem by asking what kind of power was exercised, and then was it exercised by the proper institution following the proper constitutional processes? If the answer is yes, it's valid. If the answer is no, it's invalid. And when the court takes a formalistic approach, it usually rules that a particular institutional configuration violates separation of powers. The functionalistic approach says, hey, there's no strict boundaries between legislative, executive, and judicial power. There's lots of overlap. A lot of the things that the legislature does can also be done by the executive. A lot of things that the executive does can also be done by the judiciary. Some of the things that the judiciary and legislature do overlap. So there's no clear boundaries that can distinguish between what's legislative, executive, and judicial power. They're going to overlap in practice. And so the functionalist approach says, what we're really concerned about is maintaining the essential balance between the three branches of government. And so we're only really worried about a separation of powers violation when a particular situation interferes with the essential functions of one of the three branches. And if we have interference with the essential functions of one of the three branches, then we've got a separation of powers problem. So the functionalist approach tends to be a lot more generous. When the court follows this functionalistic approach, it almost always upholds a particular institutional arrangement as consistent with separation of powers. And it's the functionalistic approach that's been dominant pretty much since the New Deal. Not all exclusive, but generally dominant. So functionalism has helped to contribute to an expanded federal presidential power. So in one area, we have the growth of the modern administrative state, primarily since the New Deal. We have the emergence of lots of administrative agencies that exercise considerable policy-making authority and discretion that has been delegated by Congress. And because the president sits at the apex of the executive branch, makes appointments to administrative agencies, removes agency officials, and can oversee policy choices within agencies. The more power that goes to agencies, the more power the president accumulates in terms of making policy choices. And all you have to do to sort of highlight this is to think about some of the policy changes that occurred when President Obama replaced President Bush, and then again when President Trump replaced President Obama. So with the growth of the administrative state, we've seen a great growth in presidential power. The second area we see are national security matters and imperatives. So historically, right, we declared war, and only after there was a declaration of war was the military mobilized to fight the war. The last declaration of war in the United States was in World War II. And I think we have fought some wars since then. And it depends on how you define war, I suppose. But we've had some pretty large-scale conflicts in Korea, in Vietnam. We had the first Gulf War. We had the War on Terror. I don't know how many others you want to cite. Beyond that, we have the sense that the use of force short of war doesn't require congressional authorization. We have a lot of presidential actions involving the use of force, as well as other steps to enforce national security and protect us against real or perceived threats. So, final general point about separation of powers in practice is to think about how the president and Congress relate to each other in terms of the scope of presidential authority. And there's a famous opinion by Justice Robert Jackson in a case known as the steel seizure case, in which President Truman seized the steel mills in order to keep them operating during the Korean War. And Justice Jackson observed that the scope of presidential power depends on its interaction with congressional power. And he sort of created a three-part framework that's useful. So one possibility is that the Congress delegates power to the president. So you can kind of think of that as the president acting with a congressional tailwind, if you want. When Congress delegates power, the president's power includes all of the president's inherent and constitutional authority, plus whatever authority Congress can constitutionally give to the president. So it's broad, and at its broadest when acting pursuant to congressional delegation. Second possibility, if I can get this to work, there it goes, is when Congress is silent. So Congress neither delegates authority nor limits authority. It hasn't acted. And Justice Jackson said, well, then the president has to have independent constitutional authority in order to act. He can't rely on any congressional delegation. Jackson also observed that in these cases, it's more likely that the outcomes will depend on politics than law in this situation. And then the final possibility is when president acts in contrast to or against congressional limitations or statutes, in which case the president's power is limited by whatever authority Congress has to constrain or reduce it. And the president can only act if Congress' effort to restrict presidential power is a violation of separation of powers. Does that all make sense to everybody? Okay. So when we think about a particular area of foreign relations law or domestic law, we have to think about first what Congress did and then how it relates to the president. Okay, so that's my 20 minutes of general background. Here's my list of topics that we can talk about. You can take a minute, I'll just walk through them. Pardon power, presidential immunity, executive privilege, impeachment or removal from office. I sort of grouped the rule of law kinds of issues over there together. Domestically, we can talk about appointment powers, removal of officers, regulatory policy control, or more on the foreign relations side, immigration, trade policy, the conduct of foreign relations, or the use of force. Anybody have a topic they want? Well, first come, first served.
Potpourri.
Potpourri for 200?
Oh. And it's not on there. Supreme Court nominee Kavanaugh has written and stated that the president does not have to follow the law if he judges it to be unconstitutional. What is the basis for that belief? Legal basis for that belief.
Well, okay. I have not read the specifics of what Judge Kavanaugh has written on that subject, so I cannot speak to his explanation for that position. In the broadest terms, every officer of the United States, including the President of the United States, takes an oath to defend and follow the Constitution. So one way of looking at it is simply to say, in keeping with my oath to follow the Constitution, I must decline to enforce any law which I believe to be unconstitutional. So that would be at least a starting point.
Okay.
Now, if we think in terms of every officer doing that, we have the president, of course, then we have Congress, they've all taken the same oath, and we've also had the judiciary, which has taken the same oath. In Marbury versus Madison, the Supreme Court indicated that essentially the court has to be the final arbiter of disputes about the constitutionality of statutes.
Right.
And I'm not sure whether Judge Kavanaugh indicated that the president could disregard a binding Supreme Court decision upholding a law because the president believed the law was unconstitutional. So I would differentiate between a circumstance where there's a dispute about the law and its validity, and there's no authoritative judicial ruling on that subject. Then I think the president is on reasonably solid ground in saying, my position is that this law is unconstitutional, and so I'm going to decline to enforce it. I think once it's been upheld by the Supreme Court, then it becomes much more difficult for the president to justify disregarding the law.
Right, and I should have told you, the context was when he was working in the Bush administration, the signing statements that were being attached.
Yeah,
to the
there were,
legislation.
every president since Reagan, at least, has been frequently issuing signing statements. Those signing statements often purport to say this is what the statute means, or this part of the statute's unconstitutional, and I'm not going to enforce it. Those signing statements are worth less than the paper that they're printed. At least from a legal perspective.
Well, that was my core of my question.
Okay, so the signing statement, a court is not going to look at a signing statement and say, oh, well, the president thinks it's unconstitutional, therefore it is. Most of the time, the presidents will be signing these statements with these positions in them to avoid appearing to acquiesce in an encroachment, or what they perceive as an encroachment on their power. So, particularly in foreign relations matters, there's not a lot of judicial authority, and historical practices and precedents become an important source of understanding constitutional allocation of power. And so both the president and Congress are often concerned not to create a historical precedent or an historical precedent that would be used against their assertions of power. But when it comes to enforcing the statute, a court's not going to treat a signing statement as having significant impact.
Very interesting.
In that particular sense. Now, there still may be a question: the president doesn't act. Can you make the president act? That's a different question.
Okay.
Yeah.
As you know, I already mentioned to you, I work overseas for the U.S. Department of Defense schools. So I'm going to mention foreign relations in a minute, because all of the military personnel anywhere in the world right now are impacted by a commander-in-chief, and they have opportunities as citizens, of course, but they also have regulations because they're in the military. They have faces, families, names, feelings. And so the importance of clarity here at home about the Constitution they defend is so important. And I need to know it because I don't have enough and I'm going back. So tell us about foreign relations and the president, please.
Okay, so when I'm thinking about foreign relations here, I'm not thinking directly about military. I'm thinking more in terms of the conduct of diplomacy and negotiation of agreements. So if we go to foreign relations, we should start with the understanding that this is an area of very strong presidential power. So there's a famous case, the Curtis Wright decision, where the Supreme Court refers to the president's power as sole representative of the United States in foreign relations matter, and refers to it as the very delicate and plenary role of the president in that matter. So we start with that premise. And so the president conducts diplomacy on behalf of the United States, and that's an area that is pretty much not absolutely free from congressional or judicial oversight, but less constrained by outside forces than any other area in which the president operates. So it's the president, for example, will also negotiate agreements, as you all probably know. So here's an example of how strong the president's power is in this area. Is Jerusalem the capital of Israel? I'm not asking for a referendum on this subject. What I can say is that Congress tried to force the president to recognize Jerusalem as the capital of Israel, directed the president to move the embassy to Jerusalem, and also to put acknowledgement of that on dual citizenship passports. So if American citizens were born in Jerusalem, it was to be designated as Israel rather than contested in some way. President Bush refused and declined to follow that directive. President Obama also resisted. There's a case called Zivotofsky, in which the Supreme Court said that Congress had acted unconstitutionally in directing the president to put Israel as the birthplace of people born in Jerusalem on their passports. And the court said this is the president's role. The president is explicitly granted the authority to appoint and receive ambassadors by the Constitution, and that's been understood for years to mean diplomatic relations, recognition of governments, etc., is the exclusive province of the president. President Trump did move the embassy, and that was also squarely within his power. So that's an example of an area where the president acts pretty much unilaterally based on the president's own determination of policy. Yeah.
But this is a foreign country, so I'm a little concerned about the power of American conduct choices by Congress, the president, etc. The Constitution gives rights, but there are foreign countries involved in foreign relations.
Yes.
And so
almost by definition.
I live there. I'm not Israel, but I live there. So I'm concerned about, because the feeling is that America doesn't rule the world, or didn't. And so I don't understand.
Okay, so this is not, whether you recognize Israel's capital as Jerusalem or not, has zero effect whatsoever on whether for Israel Jerusalem is the capital or not. It has only an effect on the conduct of the United States. And every other country in the world has had to make the same choice. Do they recognize Israel, Jerusalem as Israel's capital or not? Do they put their embassies in Jerusalem or in Tel Aviv? How do they treat that circumstance? And so it only controls the U.S. action. It has no impact on Israel's action. There are many circumstances in which the United States must make choices about how to address or respond to the actions of foreign governments. And most of those decisions are within the discretion of the president. So does the United States recognize Russian control of Crimea? That is a decision for the president to make. Now there's other considerations, there's international law there and so on. That has nothing, that the president's decision in this regard doesn't control the international regime, but it does control what the United States does vis-a-vis these matters. So there are many other examples. A few of them from the Trump administration include withdrawal from the Paris Climate Accords, right? Which Obama put us in, Trump took us out. The Iran deal would be another classic example of foreign relations matter. It was within President Obama's authority to enter into the deal. It was within President Trump's authority to withdraw from the deal. The recent debates and imposition of sanctions against Russia would be another area. And that's one area where Congress has actually taken legislative steps to override or force the president to take action that the president didn't want to do. So that's a rare example of a situation where Congress asserted authority and power successfully. Yeah.
I'm looking at on page I'm looking on page 11 where it talks about pardons. You may issue a pardon for, quote, offenses against the United States. Is there any definition of what an offense against the United States is? A local sheriff is offending against the United States?
Well, are you thinking about Arpaio when you think about that? So the offense against the United States that Sheriff Arpaio committed was a contempt of court, a criminal contempt of court. There was a federal judicial order saying you can no longer stop people based on the fact that they look Hispanic and demand proof of citizenship. But the sheriff continued to do that, I believe, for almost 2 years, and notwithstanding multiple orders after that. And then he was prosecuted and convicted. So that was an offense against the United States. This is, by the way, Article 2, Section 2, Clause 1 of the Constitution, is any violation of U.S. federal law. What it doesn't encompass would be actions by states. So this has been discussed in connection with some of the potential prosecutions of Cohen or others in the Trump orbit. Even if there were to be pardons that would relieve them from federal prosecution, the pardon power doesn't relieve them from state prosecution. If a pardon is issued, it wipes the slate clean. So it's as if the offense never happened. There's an interesting Civil War era case, I won't go into the details, that so held. So when the president issues a pardon, it's as if the offense had never happened. Now, if the president were to pardon officers subject to impeachment, it wouldn't affect impeachment. So the pardon power expressly excludes impeachment. So you could still be impeached and removed from office, notwithstanding a presidential pardon. So some issues surrounding the pardon power that have been floated in the media recently include, can the issuance of a pardon constitute an obstruction of justice? There are differing views on that, no coherent authority. Can the president self-pardon? That's another one that has been floated around in the media. And my answer is no one knows, because it's never been thought of before. So you might remember Richard Nixon did not pardon himself. And he actually refrained from, although he thought about pardoning some of his people, he thought better of it and didn't. So it was only after he left office that Ford pardoned Nixon. So these questions are interesting. Another question I find very interesting, and for which I have no answer, that's what makes it interesting, is what if there is an improper pardon? So, for example, just to give an extreme case, suppose we have a clear case of bribery, where somebody who is under criminal investigation or indictment or being prosecuted pays the president $1 million in exchange for a pardon. So what happens? So one question is, would that void the pardon? Is there anything you could, once the pardon is issued, can you go back and undo it because it was procured by bribery? Or is it too late? It's already been issued, it's wiped the slate clean. The invalidity of the process by which it was obtained, what happens with that? So that would be one kind of legal consequence sort of issue if the pardon was improper. Another possibility was, even though the pardon is not effective, if it was procured by bribery, then that's a criminal offense and you could prosecute the bribery that was done there. And then I believe if a president accepted a bribe in exchange for a pardon, that would also be a basis for impeachment. Bribery is one of the expressly listed grounds of impeachment that is in the Constitution's impeachment clause. So those are some thoughts about the pardon power. Yeah.
Could you talk a little bit more on presidential immunity and how that affects or impacts executive privilege?
Okay, so presidential immunity and executive privilege are related, but they are distinct subjects. So I can talk about both of them, but let me clarify the difference. Immunity is an immunity from liability for official conduct that the president enjoys while in office. Executive privilege is a right to prevent disclosure of communications between the president and officers. And like attorney-client privilege or doctor-patient privilege, it's a privilege against disclosure in order to encourage candor in people giving advice to the president. So looking at presidential immunity first, there's no expressed provision for presidential immunity in the Constitution. There are express provisions for congressional immunities. There's something called the speech or debate clause that protects members of Congress for things they do in legislative processes. And members of Congress are also privileged from arrest in going to and from sessions and while in sessions. Notwithstanding the lack of an express provision, the Supreme Court recognized absolute presidential immunity as an inherent necessity for official conduct. And that was another case involving our friend Richard Nixon, who managed to create a lot of interesting precedents and presidents. So in a case called Nixon versus Fitzgerald, a whistleblower in the Defense Department claimed he was fired in retaliation for disclosing cost overruns and corruption in defense contracting and sued Nixon. And the Supreme Court said, nah, as president, you're completely immune from that sort of civil liability. So we have clear authority on civil liability. Criminal prosecution, there is no clear authority. Going all the way back to the early 1800s, a famous jurist, Joseph Story, wrote that the president could not be indicted or criminally prosecuted while in office. It was just a secondary commentary, so it wasn't an actual judicial decision. But that language has been quoted approvingly by the Supreme Court in what we call dicta. It's not no actual decision, but some approval for that. During the Watergate investigation, the special prosecutor thought Nixon couldn't be indicted. That's why he was famously an unindicted co-conspirator in the original Watergate prosecutions. But that was while he was in office. Once he was removed from office or left office, there was at least the threat of an indictment, and that was sufficient to cause Ford to pardon him. So we don't know for sure whether a president could be indicted while sitting or whether they could be prosecuted after leaving office. None of this immunity protects against impeachment, right? So even if the president can't be criminally prosecuted, the president could be impeached and removed from office on the basis of misconduct. So the absolute immunity from civil liability is where we have the most information from lawsuits and judicial decisions. This absolute immunity extends to any action that's within the scope of a president's official duties. But it doesn't include efforts to block action by declaring it unconstitutional. It's just not damages. Right? So you could sue the president and say, oh, I don't know, hypothetically, your order preventing immigration from certain countries is invalid and unconstitutional, want a judicial order blocking it. That kind of lawsuit goes forward. If, on the other hand, you say you owe me money for excluding me from the country, that would be barred by presidential immunity. So, finally, it doesn't prevent you from being sued for private conduct or conduct that occurred before taking office. So there was a famous case involving another president, Clinton versus Jones, where the Supreme Court allowed a sexual harassment lawsuit against the president to go forward because the lawsuit arose out of conduct that occurred outside of the president's official duties before the president took office. This has some manifestations right now for President Trump. Anybody hear of Stormy Daniels? Excuse me, Stephanie Clifford, right? So there's lawsuits relating to that. There are also lawsuits relating to President Trump's businesses and business activities. I think some related to Trump University would be an example of that. Those lawsuits are not barred by presidential immunity either. Make sense, everybody? Yeah.
What about the emoluments clause?
The emoluments clause. So there are lawsuits pending under the emoluments clause. So first of all, a violation of the emoluments clause would not be a criminal sanction, right? So there's no crime, and it also would not likely result in liability damages-wise. Although maybe, I don't know where that lawsuit currently is. I think right now what they're looking for primarily is an order requiring the president to divest businesses that are leading to emoluments, or at least allegedly leading to emoluments. There's some debate about what emoluments mean, but I don't think that immunity is the issue for the emoluments clause. It's more a problem of, is there standing for somebody to sue? Is the emoluments clause something that's judicially enforceable? Not, is the president immune?
Can you define emoluments?
No. That's the problem. So I have read, not a paper, but a discussion of a paper that did a historical analysis of the use of the term emoluments during the 18th century period leading up to the adoption of the Constitution. And that paper argues that emoluments is very broad and includes anything of value, including business advantage. And it was that work that the lower court judge who allowed the suit to go forward relied on in concluding that there was a legitimate claim, potentially, for an emoluments clause violation. So business advantage, I think the argument against the emoluments clause is it's not a salary, it's not a direct payment, so it's not an emolument, and the response is, well, emoluments included more than just direct payments, and salaries included business advantages as well.
Going back to the question of immunity and executive privilege, hypothetically, the president in the Oval Office shoots and kills a visitor and claims that he was interfering with his official duties as president. Does he have immunity?
I think
and his chief of staff witnesses this. Can he claim executive privilege?
Okay. So, by the way, as the law faculty member, it's my job to give the hypotheticals, not to analyze them. Okay. So, working through this, I think that if you prosecuted the president while the president was in office, he would likely be immune. I think that you could impeach the president for a high crime or misdemeanor that comes from shooting and killing someone. And then I think if the president were then removed from office, it is possible that he could then be tried criminally and found guilty of murder. There are some who think a sitting president can be indicted. That's the subject of some debate. People are unclear whether Special Prosecutor Mueller thinks that or not. I suspect he will not indict President Trump no matter what the evidence shows, but rather would turn the evidence over to Congress for consideration of impeachment if there's evidence that President Trump has committed crimes of one kind or another. So immunity would protect probably against indictment while in office, not against impeachment, and almost certainly not against subsequent criminal indictment. As far as executive privilege is concerned, it would be completely inapplicable. Executive privilege exists to protect communications from staff to the president or from the president to the staff. And if the chief of staff witnesses events, those are not privileged. That's just like any other witness. Just like if your doctor witnessed you shooting someone, doctor-patient privilege would not apply. Or if your attorney witnessed you shooting someone, attorney-client privilege would not apply. Yeah.
Jumping back to pardons for just a second. Okay, the president gives a presidential pardon, and it wipes the slate clean. Could this case or similar cases be taken up by state legislatures?
Yes.
And
Not by state legislatures,
Oh,
by state
by
prosecutors.
by state courts.
Yeah, well, assuming that what the president did, or the person that the president pardoned did, was a violation of state law, then the answer would be yes.
Okay.
And not only would the pardon not prevent that, but that pesky double jeopardy provision wouldn't prevent it either, right? So you could be prosecuted for the same conduct by both the federal and state government, and that doesn't violate double jeopardy. So, yeah, if it's a violation of state law, it could go forward.
But Washington DC is not a state.
That's correct.
Would they be treated like a state in this situation?
No. So everything that happens in Washington, D.C. is the product of federal law, not any state law. And so a violation of D.C. law would be a violation of an offense against the United States. However, in the present circumstance, I guess that might be a problem for the murder prosecution. If the president pardoned himself for murdering someone, then we'd have a dilemma. But most of the currently considered prosecutions involving President Trump's business activities and others in his orbit are in New York State or other states, not in DC. Yeah.
Your slide reminds me of Jeopardy, so I'll take impeachment or removal for $200.
Okay, so I'm going to give you, do I have to give you then questions or answers? And this is not double jeopardy since it's only $200. Okay, so, and I want to be careful here. I'm talking about impeachment not as an advocate, but as an educator, clarifying the process. So the impeachment provision is Article 2, Section 4. And one thing that's important to understand is impeachment as a term refers only to a charge. So it's the House of Representatives that does an impeachment. And the impeachment is a series of charges against the president that would justify removal from office if proved. And in that sense, it's like a criminal complaint or an indictment. It's the charging document. It's not the final action. If the House issues articles of impeachment, then the Senate conducts the trial of the impeachment. And when the president is the target of the impeachment, the Chief Justice of the Supreme Court presides over the trial in the Senate. So otherwise, it's just the Senate that conducts it. But when the president's involved, the framers brought the Chief Justice in. So I don't remember if any of you watched the Clinton impeachment trial, but Chief Justice Rehnquist presided over that. He had special robes made with 3 chevrons and all of that. The impeachment clause specifies grounds for impeachment: treason, bribery, breaches of the peace, and other high crimes and misdemeanors, or something along that line, which is an odd list, to say the least. As far as anyone knows, and there's never been a test case on this, that means whatever Congress decides to impeach the president for, Congress can impeach the president for. So it does not appear that a president could go to court, let's say Clinton, and say, you know, lying in a civil deposition is not within the scope of impeachment provisions, and therefore this entire impeachment is unlawful. Everyone's best guess, my best guess would be that the courts would say, we have no authority to decide whether a particular charge is an adequate basis of impeachment. That's been confided by the Constitution in the exclusive determination of Congress. House when it issues articles, and the Senate when it convicts. I think we can imagine what kind of disaster it might look like if the House and Senate convicted and the Supreme Court said, oh no, that's not valid. That would be, you know, we'd have to figure out who was the president of the United States. And that would be a mess. So best guess would be if Congress goes all the way to the point of issuing articles of impeachment and then convicting and removing the president, whatever grounds Congress identifies would likely be sufficient to withstand any kind of litigation. So there has been some use for presidents of impeachment or the threat of impeachment. You might know that Andrew Johnson was impeached and narrowly escaped conviction and removal. Interestingly, his impeachment was based on allegations that he removed officers in the executive branch in violation of statutory provisions. That was the grounds for which he was impeached. And so that would be an example of a pretty weak ground for impeachment, and to say the least. Nixon wasn't impeached, but he was going to be, and it seems likely that he would have been convicted and removed as well, which is why he stepped down. And most people look at the Nixon case as a strong precedent for the idea that obstruction of justice would be a valid basis for impeaching and removing a sitting president. And then, of course, President Clinton was also impeached, and he was not convicted. I don't remember what the actual vote for. There were a number of different grounds asserted for Clinton, but I believe the only articles were issued based upon commission of perjury in the civil case, which was characterized as obstruction of justice. And I'm trying to remember the other one, and it's slipping my mind. But one that was tried that I thought was really interesting, but failed, was improper assertion of executive privilege was a basis for impeachment that was asserted, but the article was not approved. So I think it's generally going to be interesting, maybe, to look and see what might happen with President Trump, depending on what evidence shows up as a result of the Russia investigation. It seems like we already know a fair amount, and given what we know, I see no indications that there's a sufficient movement afoot in Congress to impeach. If there was a smoking gun to indicate that the president had in fact conspired, I won't use the word colluded because that's not a criminal law term, conspired with enemies of the United States to receive improper assistance in the election and to frustrate the electoral process, I would like to think that people would look beyond their partisan preferences and say, well, you know, it doesn't matter whether they're a Republican or Democrat. That's not acceptable in the President of the United States. Like I say, I'd like to think that. I wish I could say I'm confident that that would be the case. So, at least for a while, there was also some discussion of the 25th Amendment to the United States, which allows a president in Section 4 to be removed from office if the president is unable to perform the duties of the office due to incapacity. That determination is made by the vice president plus a majority of cabinet officers. So it's unlikely to be partisan in its determination, but it can be done in extreme circumstances. Now, if there is that determination, it's certified to members of Congress on that basis, the president can dispute that and certify to Congress that he is capable of performing the duties of the office. And if that happens, then Congress has a period of time to make the determination. And during that interim period, it's the vice president who serves, not the president, until such time as Congress would reinstate the president.
Or can he be subjected to an IQ test?
Well, you know, there's an old joke about how whether the Constitution has any actual meaning in terms of its words being fixed. One of the Constitution's provisions says the president has to be 35 years of age. And that's often cited as an example of a constitutional provision that has a fixed meaning that can be determined. But of course, law professors argue, well, does that mean chronological age or emotional age? At that point, we might have some questions about qualifications. So we can call that the rebirther movement or something along those lines. No IQ tests for all of this. Yeah.
Under what interpretation of the Constitution might the executive branch be able to deny us citizens full access to Judge Kavanaugh's papers?
Well, I think that would be executive privilege. So the papers that we're talking about with respect to Judge Kavanaugh were papers that were produced when he was working for the executive branch, and they relate to advice and opinions that he gave to President Bush during his service for the executive branch. And so to the extent that those involve sort of insights into thinking, preliminary thinking, advice, confidential communications, they could be, executive privilege would be the thing that would be asserted on that basis. I think it's also, though, in a broader sense, important to understand that as a constitutional matter, there is no obligation on the part of the executive branch to share anything. Right? There's no constitutional provision that says the executive branch must be transparent, or that documents produced within the executive branch must be made available to the public. That's a statutory matter, Those statutory obligations are found in what's called the Freedom of Information Act, which you may have heard about. Members of the public, usually the press or sometimes advocacy groups, will request release of information under the Freedom of Information Act. The Act requires the government to provide that information, those documents, unless specified exceptions apply. But similar kinds of exceptions for deliberative process and advice and so on apply under the Freedom of Information Act. Yeah.
Separation of powers.
Okay.
You know, separation of powers. I don't know if there's anything in the Constitution that specifies the separation of powers, or has this been derived from court rulings? And then I have a quote that you'll be familiar with. John Marshall has made his decisions, let him enforce it.
That's Andrew Jackson.
That's right.
Okay.
Separation of powers.
Starting with separation of powers. I think that unlike some state constitutions, which expressly say separation of powers and use that term,
Right.
the U.S. Constitution does not use the term separation of powers. But I think separation of powers is very clear from the language and structure of the articles, first three articles. So Article 1 says legislative power shall be vested in
Right.
Congress.
Right.
Article 2 says executive power shall be vested in the president.
Yep.
And Article 3 says judicial power shall be vested in the courts, the Supreme Court and such lower courts as Congress may from time to time ordain and establish, or something like that.
Right.
So when you identify powers by name and vest them in branches of the government, I think the inference that there's a separation of powers at work is inescapable. Then you can back that up by the ratification debates that were occurring contemporaneously, where the critics of the Constitution criticized it for lacking separation of powers. And Madison, Hamilton, Jay responded by highlighting the role of separation of powers in the Constitution and explaining how the checks and balances written into the Constitution were consistent with separation of powers. So I think that would be my response to the first question.
Right.
My response to the second question, Mr. Justice Marshall
Yes.
has made his ruling, now let him enforce it. So the first thing is that famous quote is somewhat apocryphal, and it probably is a case that the decision in question, which is Worcester versus Georgia, if I remember my cases correctly, didn't really require Jackson to do anything to enforce it. So that's neither here nor there. That was the 1830s. A lot of water has come under the bridge since the 1830s in terms of judicial power and the rule of law and federal supremacy. So I would cite examples like the federalized National Guard being called out to enforce Brown versus Board of Education of Topeka as an example. I'm also really struck by, and I frequently start my con law classes, by Al Gore's concession speech after Bush versus Gore, in which we have the sitting vice president, second in command of the world's largest military force, giving way because of a 5-4 vote of old people without any special superpowers. I mean, it's not like the Avengers were there to enforce the order, but the rule of law was there. And from my perspective, this is a really, really important question. Because if we cannot transcend our hyper-partisan, polarized points of view enough to pay attention to the rule of law, then all of our institutions are in danger, I think.
But you made a good point for me. Bush v. Gore, he followed the
That's right.
Supreme Court ruling.
That's right.
Jackson did not.
Jackson said let him enforce it. Jackson didn't have to do anything.
that's
So he
pretty
didn't
good.
exactly not follow it.
Okay.
Right? Now, you know, if you go back to Marbury versus Madison, which is the first time when the Supreme Court said an act of Congress is void as unconstitutional, it was interestingly decided in a way in which the Supreme Court said, well, we got this power, this power, this power, this power, but Jefferson wins. So there was no need for the president to comply, and there was no way for the president to defy the decision, even if the president disagreed with all that Marshall had said, except that he wins. Okay, are we?
Well, I have one final question.
Okay.
In your opinion, do you think the U.S. Constitution has been damaged in any way by the current administration?
Damaged. I think it's too soon to tell whether it's been damaged. I think certainly actions by many political actors over the last 20 years have stretched the fabric of the Constitution in ways that threaten to tear it. I think we're still not clear yet on whether that fabric is strong enough and resilient enough that if we maybe put it through the wash once, it'll come back into shape. So I guess I'd say the jury is out. Want some quick concluding observations? Do I have time?
Go ahead.
Okay. So concluding observations start where end where I started, with the idea that congressional dysfunction facilitates the expansion of presidential power because inability to act creates a vacuum and Congress can't assert its own power in response. The second observation, which I haven't made yet, but I think is an important one, is that politicians only complain about presidential power when it's politically expedient to do so. So Republicans were always complaining about President Obama's overreach of power, but they're silent about the Trump administration's overreach of power. But the Democrats complain about Trump when they were silent about President Obama's broad assertions of power. So I'll believe that a politician cares about reining in presidential power and preserving separation of powers when they care about it, because even though the president is doing what they like. And this is the same thing we see with federalism as well. People are all in favor of states' rights when they don't like what the federal government is doing, and federal power when they don't like what the states are doing. And it's, you know, equal opportunity hypocrisy on these subjects. And it's because people want the things that they want, and the ends kind of tend to justify the means. So both sides tend to be silent when they hold the White House. A final general observation that is that expansion of presidential power is likely to continue. I don't see any signs that it's going to suddenly shift or turn around, and it's likely to test the strength of our political and legal institutions.
All right.
So thanks so much for your attention.
All right, we're starting to run up against some time constraints. I think we've learned a great deal today about the interaction of constitutional authority with presidential power. So on behalf of the Public Affairs Forum and the Endacott Society, once more I'd like to thank Professor Levy for being with us.